My understanding from the briefs is that your position is that components of a gun are not arms. So a barrel is not an arm, a receiver is not an arm, and a magazine is not an arm. Hence, the states are powerless to regulate. Hence, the states have the ability to completely ban all of those things without even implicating the Second Amendment or Article 1, Section 24. Have I got that right?
No, Your Honor. It is our position that each of those things individually is not an arm. They don't meet the definition of arm, but that does not mean that the state could ban any of them. If banning one of those things would undermine the purpose of the Second Amendment right, then it would not be allowed because it would infringe, it would impair the right to bear arms.
But I thought under your analysis, question one is it an arm? And under your definition, if you're defining every component of a gun, even the most necessary components, out of the definition of an arm, then you don't get to question two.
Well, you don't. You do if the restriction would impair the right to bear arms. And here, there is no firearm that requires a large capacity magazine to operate. The other side has conceded that, and that is why a large capacity magazine is different, for example, from like a trigger. If the state banned
but sticking with the first question about whether it's an arm, maybe what I'm hearing you say is that a large capacity magazine is not an arm, but a regular capacity magazine is an arm?
No, Your Honor. Some things that are not arms, the state still could not ban because it would impair the Second Amendment right. For example, triggers. For example, perhaps a complete ban on firing ranges might impair the Second
How about
Amendment
magazines?
right. Magazines are not arms, but the state could still regulate them heavily. Whether the state could completely ban
Isn't a magazine just as necessary to the operation of a semi-automatic as a trigger?
Perhaps to some, Your Honor, and maybe if the state banned magazines completely, that would be a much harder question, I think. But large capacity magazines, the other side has conceded, are not necessary to the operation of any firearm as intended.
But I think you're still collapsing question one into your other policy answers.
I respectfully disagree, Your Honor. I agree that there are some things that are not arms that the state still couldn't ban because they are necessary to the operation of arms. They are necessary to have the right be meaningful, like triggers, for example, ammunition. But large capacity magazines do not fall into that
Is a
category.
magazine with a capacity of 2 cartridges an arm?
The magazine itself is not an arm, Your Honor. The magazine does not meet the basic definition of an arm. It's not something used to strike at another. It is just a container for ammunition. So
under your theory, the state could ban any magazine larger than 2, the ability to hold 2 rounds?
No, Your Honor. If, as I said before, just because something is not an arm doesn't mean the state is allowed to ban it. You have to look at whether it impairs the underlying right to self-defense. And here, a ban on triggers, for example, would clearly impair the right to self-defense because you couldn't use virtually any firearm.